just check the vehicle, just make sure. From there, from there, from down there. Okay, all right. That's what we do.
Hello. Good morning, ladies and gentlemen, and welcome to the second day of the National Prosecutors Conference. My name is Samuel Smwaka, and I'm honored to be the Director of Programs for today. I hope you had a restful night. We are back today, and we have a lot of exciting topics that will be tackled by a lot of distinguished speakers. So housekeeping first. Those that are in the back, kindly walk to the front. We fill up the seats that are in front. Ushers, kindly help the delegates. Let's get settled. Okay, the first topic for today. We are ready for the first topic today, and our presenter is already in front, Mr. Simon Marsh from the Basel Institute on Governance. Mr. Marsh, you are welcome. This mic or this mic? How do we? Okay.
Good morning, everyone. I'm sorry for being late. It seems that Zambian road users have taken a leaf out of the book of Kenyan road users and decided to create some extra lanes. So thank you very much for the invitation to come and speak here today. It's a great honor to be here and to see so many of you. I'm hoping we can have an interesting discussion about one of my particular areas of interest, which is international cooperation and how it's evolved, some of the challenges that exist, and potentially some of the solutions to overcoming those challenges. As I was introduced, my name is Simon Marsh. I've spent the last 26 years in law enforcement, which makes me an impala amongst the leopards here today. So I'm hoping that you'll go easy on me. So for the last 12 years, I've lived and worked in East Africa, and my role nowadays is to be the head of Africa for the International Centre for Asset Recovery, which means that I look after the technical delivery of our programs across this great continent. That being said, I also keep my hand in on the actual work, so I'm hoping we can give some real examples of operations, areas of interest, and issues that may be very relevant to what we're here to talk about. I've been working in Zambia for about 4 years now. The DPP assures me that my Zambian passport's on its way, but I'm still waiting. Maybe today's the day. So a little bit about ICAR and what we do. I'll be very brief because you can look this up on a website. We give training. Many of you may have attended one of our training courses. We give case advice on live cases, which is the core of what we do. We give help on legal policy and institutional strengthening. And lastly, but not least, we do global policy, dialogue, and innovation. And many of you will have been exposed to that in the last few years. This is an out-of-date map, so I'm not going to linger on it because it no longer is up to date, but there's an idea of some of the countries we work in, but it's definitely changed since this map was done. So getting to the meat of the matter, the concept of sovereignty. What does sovereignty mean? Every country has sovereignty. It's a very important aspect of a country's identity, of a country's right to self. Yet, it also comes with challenges. When we look at I was listening to the World Service this morning on the way here, and we listened to what's happening in Syria, what's happening in Sudan, what's happening in DRC, what's happening in Ukraine, what's happening in Gaza. Are these issues that affect the sovereignty of those countries? No entity outside the sovereign power of the state can exert its authority in the state. So effectively, the authorities of one country have no power outside of that country at all. So where does that leave us in the world of crime, which knows no borders? How can we exert our ability to investigate organized crime if sovereignty goes against that principle? I'll come back to that point. But first of all, what are the challenges we're facing? What sort of outgoing illicit financial flows are we encountering across the continent? I'm speaking in quite a continental context here, but I'm also going to speak about Zambians. So some of the figures that are thrown around saying $1.6 billion a day in outgoing IFFs, illicit financial flows. How they've come by that figure, I have no idea. Whether it's based on some sort of statistics or whether they pulled it out of a hat, I can't tell you. What I can tell you is IFFs leaving the country and the continent. And that impacts upon the government to provide services to its people. We know that. So how are some of the ways we lose it? And again, I'm preaching to the converted here, but it's worth exploring some of these challenging areas. So diamonds, extractives, precious metals, all of these are very relevant issues, particularly for those countries which have large reserves. And of course, we all know Zambia has large reserves of precious metals and precious earths. So that vehicle you can see there, that picture was taken here in Zambia, and that's gold being trafficked out of the country in hidden compartments in a door. Just one example of how extractives and precious metals are used to steal the sovereign wealth of a country. Many of you may have seen the Gold Mafia series on Al Jazeera. I've also explored it in several other jurisdictions, and the scope and scale of the outflows linked to those entities are staggering. We're talking about percentages of countries' GDPs, not small money. And where's it going? That's the question. So something that's often commonly misunderstood, I feel, is the concept of trade-based money laundering. There are various ways of trade-based money laundering, but the concept of it is actually very simple and also quite hard to detect. So let's put it into a really simple context. For example, a retail outlet. So let's say, for argument's sake, it's a shop that sells office furniture in Lusaka. Is sent an invoice for a sort by a company purporting to be a wholesaler in the United Arab Emirates. That retailer will never actually receive those goods. If it does, it will just receive a nominal delivery, maybe 5 tables and 2 chairs. However, they've made the payment and they present the invoice if required to justify the reason for making the payment to the UAE, when in fact, the whole thing is just a method to justify the movement of funds. And of course, any basic audit is only going to identify that the payment matches up with the invoice. You would need to go into much more detailed audit to identify that in fact the goods have never arrived. Or they might say it was a forward payment for goods that will arrive in the future. And I've seen all sorts of variations on this principle, on this concept, to the point where companies have sued another company, gone to court to initiate proceedings, then agreed an out-of-court settlement and had it stamped by the court in order to justify the movement of funds when in fact there never was any dispute. Simply a way of moving huge sums of money and making it very hard for law enforcement. And subsequently, as prosecutors, as you can imagine, quite difficult for you to prosecute without the evidence. This is money laundering. Underground banking, Hawala, the Chinese underground banking system. Under these, I include cryptocurrency there, but it's not really underground banking, not nowadays. Now, you might say to me, there's no such thing, Zambia, whatever it is. Personally been involved in money laundering involving Hawala transactions. It's there. It's not going away. And just to explain, I'm not insinuating that all underground banking systems, Hawala or their other equivalents, are criminal, because they're not. But there are elements, like in any financial transaction, or in any financial system rather, which includes degrees of criminal activity in the law. So we need to understand them. That's the most important thing. As prosecutors prosecuting serious and organized crime, you need to understand how these systems work, because it's your job to explain to the magistrate or the judge how it works, not to assume that they know. And that means that your investigators need to present you with the evidence to enable you to do that. The concept of beneficial ownership is talked about a lot. If we're to take, for example, the UK Companies House, something like 40,000 companies a day are registered. How could you possibly manage the beneficial owner system of 40,000 companies a day? You can't. It's impossible. So how would we use beneficial owner in the context of organized crime? Let's say, for example, we acquire a property in London. It's uncommon. We register it in a company name. The directors of that company are themselves companies in another jurisdiction, as are the shareholders, and not necessarily in the same jurisdiction. Directors of those companies also have directors and shareholders as other companies in yet more jurisdictions. What you're creating here is spider's web of ownership, where it's going to be remarkably difficult, and I know because I've done it many times, to follow that chain to the ultimate beneficiary. Because, as we'll talk about in a minute, we're playing by a different set of rules to the people, the enablers, whose job it is to set up these structures. So it could be argued that it's often a requirement to declare who the ultimate beneficial owner is. However, it's practically to verify this, and even more difficult to demonstrate it to an evidential standard, because we don't play by the rules. So how do we overcome these quite substantial challenges? And you're going to tell me, we're prosecutors, we don't do intelligence. Or maybe you don't, but you need to be having oversight to do, because that's going to be guiding, if it's done properly, the investigation. And the first thing when an investigator comes to me and talks to me about a case is I say, where's your open source intelligence? And if they haven't done any, then I wonder why not. Is it because they don't know how? Is it because they don't have the tools to do it? Or is it because it simply hasn't crossed their mind? Well, the reality is we live in a technically evolved world where everything is online. People are using social media all the time. People are using digital tools for all things. This gives us an opportunity to be able to develop a very enhanced picture that's going to guide our investigation. So when your investigator comes and presents a case to you, the first question has got to be, have you done your OSINT? Have you done your intelligence? If not, why not? We need to think about how we're using technology. Now, I've got 2 phones in my pocket as I'm speaking. I've got a third one probably in my car. I have 6 SIM cards for 6 different countries because I travel so frequently. What that means is I have a wealth of information about my lifestyle in my pocket. Now, your investigators should be exploiting that information because that's going to give you, potentially, the evidence to demonstrate how criminality is taking place, how the conspiracy between different entities has evolved. How are they communicating? How are they arranging the bribes? How are they arranging to deliver the drugs or whatever it might be? It's on the phones. It's on the computers. It's on the hard drive. Years ago, we were investigating a Nigerian state governor called James Abori. This was when I was still in UK law enforcement. He was the governor of Delta State, which is the oil-rich state, or one of the oil-rich states in Nigeria. And through corrupt activity, he had obtained enormous wealth in the hundreds of millions of USD. So he had enablers, of course, people whose job it was to acquire assets on his behalf, but not in his name. And one of those was his solicitor, a guy called Gohill, London-based solicitor. So we searched that solicitor's office with a warrant, of course. Didn't find anything particularly interesting, so we're leaving the office. And one of my detectives, he says, hang on, before we go, there's an old it's over there in the corner, and it's boarded up. And let's just go and have a look, just to be on the safe side. So he pushes the wood out of the way and puts his arm up and has a route around. Guess what, sir? A hard drive with the entire empire of assets belonging to our Nigerian governor. Good old detective work. But my point is, the evidence is on the electronic format, on the electronic gadget. Then we need to think about our international engagement. So back to my phone scenario. I've got 2 phones in my pocket. On the apps on my phone, I can move money from one country to another in probably less than 10 seconds. How long does it take us to get that transaction in evidence? So a lot longer than 10 seconds. Potentially years, because we are going to have to make requests for evidence to other jurisdictions. And many of you will have had the experience that international cooperation can be something of a minefield. It can be something that requires us to be extremely innovative and patient. So that's where it's really important that we manage our international engagement properly. And I'll talk again about that later. Strategy. How are we approaching this case? Prosecutor-guided investigations. What advice are you giving your investigators? Where should they be starting? Where should they be progressing to? What are their parameters? Seek to achieve. And I said earlier, I know you're not there to seek intelligence, but you are there to guide those who do. There's so many tools available. And we need to understand which of those are relevant, which of those can be utilized, which of those is going to enhance the quality of the case ultimately you seek to put before the courts. Same applies with international intelligence. We've got all sorts of tools out there. And I'm pleased to say that Zambia is one of the best utilizers of those tools. Again, we'll talk more about them in a minute. So the IACCC is a big friend to Zambia. It's a multi-jurisdictional center physically located in London with representatives of Australia, New Zealand, States, Singapore, Switzerland, and various other partners, which means that you can make one request for intelligence and receive a multinational dissemination back in return. And Zambia has done that several times. And it means that you save a lot of time, of effort, prevention of duplication. It costs nothing. And it also assists in facilitating a fast track MLA afterwards. They will help with translation. They will help with fast tracking it. Again, a really useful tool. It doesn't require very much. It requires a referral from a mandated agent, of which the MPA is one. Very simple one-page letter or even an email will suffice. And these are people we meet regularly. They've been to Zambia several times. A useful tool. A peer-to-peer and liaison officer network. The best way to engage with another jurisdiction is to speak to them directly. You have a number of jurisdictions who deploy liaison officers around the world, including UK, Germany, Netherlands, Australia, and so on and so on. They will all have one with responsibility for Zambia, and I know many of them come here frequently. They are your point of contact, and they are there to help you, and obviously to help them in return. If you have trouble finding out who the person is here to help with, to put you in touch with the right people if they exist, or to find another way of facilitating that contact. I always say that one of the things I try very hard to do is maintain my Christmas list. So at Christmas time, I send out emails to law enforcement counterparts around the world who I've known for a long time. It doesn't matter whether we're not doing any business. It might be that I just wish them a happy Christmas and a restful period, because at some point I might well need to call upon their services. So maintaining that relationship means that when I do pick up the phone, I actually know who they're talking to and haven't forgotten. I'm sure we all know about Interpol. Egmont is, of course, the network for financial intelligence units to exchange information. And, of course, he is the point of contact there. And then some of the technology available to us. These are just examples of what may be able to help you. So Greylist is one example. I'm not promoting these tools. I'm just saying they're out there. But because time is against us, I'm not going to go into them. They are certainly ones that have been used for Zambia and can be used in the future. And then the ones I really like. These are our forums for international cooperation. So Zambia, as many of you may know, is a focus country on the Global Forum for Asset Recovery. What that means is internet on turbocharge. It means but delegations from multi-agencies will go and have bilateral meetings with international counterparts on live cases. A delegation went to Baku in Azerbaijan in June, and a delegation will go to Vienna next month to have these live case meetings. And it means they get results. It means they know how to cooperate, they know what's happening between the different jurisdictions and what the next steps are. It puts names to faces, and it removes the anonymity of the international cooperation process. I've just spoiled on this one because I've already spoken about it. So for you guys, the prosecutors, the apex strategy. What is your prosecution strategy? There's nothing worse than seeing a prosecutor turn up to court to present a complex case and drowning the magistrate or judge in irrelevant nonsense. Your Honour, the procurement rules were not followed to the letter because the I's were not dotted and the T's were not crossed. I'm sure that's very relevant, but that is not the crux of your case. Where's the money? Leave a very good first impression, because that will stick in the mind of the magistrate or the judge. Where is the fraud? How was the money stolen or misappropriated? We can go into the extraneous detail later on, but let's implant the key element of the evidence. Visualization. What I like to call the 10-year-old test. Can a 10-year-old child understand your case? Can they conceptualize how you are trying to explain that the accused are guilty? If not, then perhaps your case is too complicated and you need to find a better way to visualize it. Not because I'm in any way insinuating that the judiciary are stupid, because that's not the case. However, if you are presented with a very complex set of circumstances, you need in your mind to be able to understand it, because all of us as children, we learn to read from pictures. That's how our brains work as human beings. So find ways to visualize it, timelines, link analysis. Of course, we have the evidence to back up the visualization, but we need to have a very easily comprehensible picture in the first instance. And I wonder if our colleague, the Honourable Judge, would agree with me or not, that it's very easy for anyone adjudicating the matter if they can comprehend the whole set of circumstances in their mind from the outset. What aspects of your prosecution case will the defence try and pick apart? And how can you nullify that? How can you preempt what evidence the defence might seek to have cast out? How can you seek to nullify what evidence defence witnesses might bring about? How might they approach the cross-examination? They say court is a theatre and everyone involved is an actor. So this is why you need to think about your choreography. And do your witnesses know what's expected of them? Have they been to the courts and been familiarized with the process? Do they know where they'll be standing in the witness box? Do they know how the evidence will be presented? Do they know what's likely to happen in cross-examination? Witnesses are very intimidated coming to court, particularly for the first time. They're going to be a little bit scared, perhaps. They're going to be potentially worried about repercussions of giving evidence. It's ultimately your duty as the prosecutor, the apex in this case, to make sure that your witnesses are competent, happy, and confident. And have you thought about how you're going to present your evidence in chief from international testimony? If it's being done via video link, have all of the correct procedures been put in place? Where is your witness in another jurisdiction actually giving evidence from? Are they in their house? Are they in an embassy or high commission? Are they in a courtroom? Every country has different procedures, so you need to make sure that you fully understand those and everything is in place to make it run smoothly. There's nothing worse when having international evidence, and he goes to start and it doesn't work. Because then you're wasting the court's time, you're wasting your time, you're wasting the witness's time, and everyone gets annoyed. So I talked about the 10-year-old test already, so I'm not going to go into that. So I'm going to talk about international asset recovery. As prosecutors, many of you may be involved in asset recovery. So asking yourselves, and this is at every stage of the process, from the first contact you have with the investigation team right to the point where you're looking for adjudication. Is there a parallel investigation? If so, what protocols have been agreed rather? I mean a parallel investigation with another jurisdiction. And Zambia has several of those ongoing. What is going to be the protocol for sharing information? What is going to be the protocol for sharing evidence? There are different types of MLA requests. There is a request for basic information, witness testimony. There is a request for coercive measures, such as searches, surveillance, bank account information. There is a request for the freezing of funds. And there is, of course, a request for return of funds. All of these may require different levels of information to justify the domestic action, particularly if you're asking for freezing or confiscation of funds, because chances are someone in another jurisdiction is going to have to go before a court and present the circumstances to the judge to justify that measure. If they haven't got enough, they simply can't do it. Are you sure you've got enough information? Speak to your counterpart in another jurisdiction. That's why we have the GFAR process. Engage with them and say, this is what I'm going to be sending you. Is this enough? If you're restraining a going concern, a business, a garage, a hotel, whatever it might be, how are you going to manage it? What's going to happen with the live assets? What's going to happen with the depreciating assets? How are you going to deal with that? Have you started discussing asset sharing agreements? Because many of you will know that under UNCAC and the other protocols, there is a provision for the return of assets that belong to Zambia from other jurisdictions. It's not an easy process, and it generally will require an asset sharing agreement. And that's where it's really important from the early stages to start planting that seed and saying, this is what you'll be looking for in the fullness of time. And you would like ultimately to be able to explore that avenue. Is there a treaty in place? There might be, there might not be. Have you engaged the Zambian High Commission or Embassy in that jurisdiction? Because ultimately, they may be required to apply some diplomatic pressure at ministerial level. If there is going to be an asset sharing agreement, will the other country require that there's an independent implementing entity? What does that mean? It means that they're not going to give the money back to the government of Zambia, but they will want someone independent to implement the project, whatever it might be. And yes, I know that's a very controversial subject, but that's the reality of the world we live in. And lastly, have you thought about what the media is going to say? Because that nowadays is a very, very important thing you need to think about. Make sure you have a media strategy in place. That's important that you as the prosecutor and the PR people do together. Because there's going to be either very good publicity or very bad publicity or something in between. International cooperation is not easy. It requires a degree of understanding some of the nuances of different jurisdictions and how they treat international cooperation as a concept. For example, in the bailiwick of Jersey, which many of you will know is not the state in America, but a small island off the coast of the UK, police have the power to apply an indefinite freeze on a bank account with no jurisdiction, no juris require for a legal order. They can do it off their own volition. In Switzerland, the prosecutor can apply for an urgent restriction on an account of a request of another country, and they have done this for Zambia. They can do that in advance of the formal MLA. However, they are required to show your MLA to the suspect if they ask for it. The bank is required to inform the bank account holder that there has been a request to access this account. So again, your confidential investigation might not be so confidential. Things to think about. This is where I come back to the nuances of international investigations. And then the elephant in the room, cryptocurrency, the one thing that comes up all of the time because we know it's here to stay. It's all around, it's talked about, it's mooted. Do we know much about it? Some might not. Freezing international assets, which include cryptocurrency, then you need to make sure you have systems in place to do it. And that might well necessitate you procuring a company with speciality skills in doing so, because otherwise it's going to move pretty quickly. So ultimately, once you've recovered your asset, what are you going to do with it? I know there's protocols in place for this, and I know there's also legislation being tabled before Parliament. The most transparent and effective thing you can do with assets is social reuse. How is that asset going to be used for the tangible benefit of the people of Zambia? Because you can say to them, yes, it's going to go into the consolidated fund and the government coffers. And they'll say, well, how does that benefit me? And they've got a point. So you'll see there a check being handed over, and that was from recovered assets, which are going to be used to fund bursaries for higher education for students in Zambia who wouldn't necessarily be able to afford to go to university without that bursary. So to me, that's a really good example of social reuse of assets. In the bottom there, this is a case in Kenya where the assets were used to purchase ambulances that would be used in rural areas, and that's why they're Land Cruisers. Now, neither of them are perfect for sure, and there are plenty of other examples out there, and this is one of the common themes that we debate about for days. But ultimately, particularly where we're looking at demonstrating to the public that we are serious about recovering stolen money, we've also got to be serious that it's used in the right way. So this is a question I always ask in a presentation. Can I just have a show of hands? Does anyone know what you're looking at there? You just found a piece of paper with that written on it. We got, what, 200 people here? Okay, one person does. 2, 3, 4. Okay. Can anyone shout out what it is? It's a Bitcoin wallet address. So your investigators are out doing a search and they found that. Are they going to seize it? 90% probably wouldn't pay any attention. But that could potentially have millions and millions of dollars on it. That's why it's also very important to be aware of what you're looking for. And that brings me to the end of my presentation. I've gone through it fairly quickly. I hope it's been something to make you think. And that's the whole idea of it, is to have conversations and to get people thinking about what to be looking for. And most importantly, as prosecutors, to be engaging with your investigators. And I stress this 3 or 4 times now. Engage with your investigators at an early stage and make sure that you're on the same page. Because investigators and prosecutors are banging their heads together, and we're probably not going to have a successful prosecution. So thank you very much for your attention. I look forward to speaking with you during the course of the day in tea breaks, and enjoy the rest of your conference.
Thank you very much, Mr. Marsh, for that wonderful presentation. Ladies and gentlemen, another round of applause. I'm sure you can stick around for a few questions. About 5 minutes for a few questions. 1, 2, 3. Okay. 1, 2. Okay, 2.
Good morning. Mine is to maybe ride on his experience on how he can maybe clarify on a dual citizenship. We have had matters in the past in this country where maybe, illicit money is stashed outside and then you want to extradite. You have difficulties because the other recipient country is actually unable to surrender the victim and even the proceeds. With your vast experience, how have you managed to go around such an issue where the other country says this is our citizen and we cannot release him? I wanted you to clarify on that one. Thank you.
It's an interesting question. We've had challenges in the past where jurisdictions actually have an offence for someone to be a dual citizen, or in particular for a public officer to be a dual citizen. And that creates a problem because you have the issue of dual criminality, where it's an offence in one country, but it's not necessarily an offence in the other country. So how do we put that into the context of a criminal investigation? There are some countries, let's be very clear, who will not extradite their own citizens. So what that means in practice is that in those circumstances, there is very little prospect of us ever being to extradite that person to Zambia to face trial. So then, do we have the question of recovery of assets? Maybe, depends on the circumstances. Does dual citizenship prevent us recovering assets? Not in my experience, no. Because generally, it's not going to impinge on the human rights in the other jurisdiction of that person, because they have the right to defend themselves, either in person or through their legal representatives. And that means that due process can be followed. So certainly, I haven't personally encountered a situation where we've been unable to carry on with the recovery of asset proceedings because of dual citizenship of an individual. That being said, I think there are jurisdictions who traditionally are more obstructive than others, who may well make it difficult for us to be able to do that. But we have to treat each set of circumstances on its own merits.
Good morning, Mr. Mash. My name is Brian Sianyengo, public prosecutor from Lusaka province. My question is closely related to his. Doesn't he hinge on their would externalize funds that are gotten from criminal activities? Say, for instance, someone invests in a foreign country and that country is not willing that that person should be extradited to Zambia for prosecution. So I think would be the best practice so that international standard academic ensure that those funds you gotten were committed from.
You cut in and out, but I think I got the gist of it. So I think the best scenario in that context is you have a parallel investigation between the two jurisdictions. Because, of course, the other jurisdiction, assuming that they have the ability to investigate and prosecute in the circumstances, may well be able to conduct criminal and NCBF proceedings in their own jurisdiction and potentially to recover the proceeds to Zambia. So I'll give you an example. We had a very tricky investigation in Kenya, which involved the former Minister for Power and the CEO of the Kenya Power and Light Company, which is a parastatal, so a government-owned company. And what was happening in practice was that percentage of all of the subcontracts awarded by that parastatal were being siphoned offshore into a company in Jersey. So that Jersey initiated their own investigation. When they came to Kenya, they had MLA going both ways, but the relationship struggled. So we found ourselves in a catch-22 position. How do we move forward with this when we know that Kenya's not going to extradite these individuals? Jersey's not going to be able to conduct its own proceedings without that two-way assistance. So we had a conversation with the authorities in Jersey and said, how about you prosecute the corporate entity that was set up to receive the bribes? So they said, why not? So that's what they did. And the corporate entity had no choice but to plead guilty because the evidence was overwhelming. As you know, with a company, the directors have limited liability. So the directors who were not present were not themselves found guilty, but the nominee directors were pleaded on behalf of the company without accepting liability. The reason is because we were able to use that mechanism to release the £3.6 million that was in the company accounts, which was then returned to Kenya, minus some. So there's an example of how it can work. And as I said earlier, that it depends on the individual circumstances of each matter. But if there's a will, there's a way. And that's where dialogue and international cooperation at every level is so important. Is there one more?
Thank you very much for those two questions, and thank you to Mr. Bash for the detailed answers. So without any further delay, we are moving to the next presentation. Allow me to welcome to the front Judge Hamaundu, Chairperson of the Anti-Corruption Commission. He'll be accompanied by the learned Chief State Advocate, Ms. Nkumbiza Mumba. Let's encourage as they come to the front. The topic is trial advocacy, building a case theory and strategy. I'll not go into the bio. I think it was beamed at some point. Thank you very much. We'll start with Judge Hamaundu to address us, and then the learned CSA will pick it up. Thank you very much.
Thank you very much. I think I'll make my presentation while seated. Just so that my papers can fit. I can see my papers won't fit there, and I'll have nothing to prompt me. Thank you. Thank you, ladies and gentlemen. Um, yes, my presentation is about trial advocacy, building a case theory and strategy. Now, although the heading for the topic suggests that we are dealing with trial advocacy in general, meaning that it applies to both prosecuting and defense advocates, my presentation will be from a prosecuting counsel's perspective, because this conference is for prosecutors. Let me say here also that my presentation really is not a theoretical paper, but it's rather a talk or based on my experience on the bench. So this really is all about what I have observed while sitting on the bench. So in my view, really, what is trial advocacy? I think from my experience, trial advocacy is really about counsel, uh, pro- uh, uh, um, counsel persuading the judge to see the case their way. I think that is perhaps how I would define it. Just persuading the judge to see their way. So while yeah, it may be said that the prosecution's or the prosecutor's role is simply to present the evidence and then let the judge see what the evidence speaks to, which is what happens anyway in most cases, or at least from my experience. We the prosecutor, or indeed even the defense counsel, would adduce evidence and simply say, well, I've put the evidence before the judge. Let the judge now. It is for the judge to go through it and see where what the story is, or where the case is going. But I think that, and I know that in some cases I've experienced that if counsel does put a little bit more, if counsel sets out to carry the judge along, that is what I think trial advocacy is. It actually, um, it can persuade the judge, to go or to decide in the way that the counsel has put their case. Sorry about that. Why should the prosecutor go extra lengths the judge to his or her of the facts? It's because the this is because I feel as if the mic is. What about this one? Yes. Yes, I was saying, why should the prosecutor go to extra lengths to persuade the judge to accept his or her version of the facts? And I say this is because, as a prosecutor, you have decided to prosecute the case because you are convinced in your professional view that an offense was committed. And so, if you are convinced on the material that you have that an offense was committed, then you would want the judge to agree with you. But in order to persuade the judge to agree with you, there will be need for you to package your case in a very compelling manner. So you will therefore be required to formulate a theory, which you will set out. You will therefore be required to formulate a theory, which you will set out to prove by the evidence that you will place before the judge. Now, what in this case, what is the theory? Uh, there is nothing academic about a theory in a case. It's just the story. So when you read the case, I mean, when you read the docket and the evidence on the docket, there is something that the the, the statements therein. There is a story that the statements therein bring out. The story will be about an events, something that happened. Let's say if it's a murder case, the story will start from somewhere, uh, leading up to the murder and conclude somewhere. So you, as the prosecutor, when you take the matter to court, you are simply saying that, telling the court that I'm going to prove by this evidence that on such and such a day, this accused perhaps set out to kill the deceased, and he did so by perhaps he first met this one, planned it this way. He then went ahead to carry out the plan, and killed, this person up to that. So that is really the theory or the story that is coming out of there, and that is the story you are telling the judge, that this is what you are going to prove. So in short, if the theory is something that you prove, and so is the story in in our case, because it is that story which once proved will uh, will then determine whether the accused is guilty or not. It will determine whether you have proved the case or not. So in this case, your main aim will be for the judge to come and arrive at findings of facts that constitute your story or theory. Now, in order for your case to be presented in a compelling manner, you must be alive to a number of very crucial issues. First, you must know that any offense is tried and decided on facts. If there are no facts, you cannot even apply your knowledge of the substantive law on any criminal matter. Otherwise, you'll be applying it in a vacuum. Secondly, you must know that the facts can only be established from the evidence that you place on the court's record. Then thirdly, it is very crucial to understand that the evidence that you wish to place before the court will be subjected to the substantive law of evidence and the procedural law regulating the manner in which that evidence should be introduced onto the court's record. And because the evidence is regulated by the law of evidence, the prosecutor must understand that the law of evidence, insofar as trials are concerned, is simply about one thing: admissibility. In other words, what evidence the court will accept on record and which one it won't. This is therefore the most crucial part of the trial. Yes, I've always said during trials that the I think the whole trial, and this is especially so in a criminal trial, is all about, or rather, yes, it's all about what comes onto the record and what shouldn't. So you are really dealing with only one thing: the admissibility of evidence. Of course, there are a lot of rules surrounding the admissibility of evidence, but I think for the prosecutor, it's very important to note that when you go to trial, the main issue there is whether you are able to put your evidence on record. Because if your evidence is not on record, then you have no story. There are no facts before the court on which a decision can be made. So really, for the prosecutor or indeed any other lawyer at the trial, the most important issue is simply the law of evidence, which in turn is really just about what is admissible and what is not. So, as a prosecutor, then you need to either be well versed in or keep reading around the issues that surround the admissibility of or weight to be attached to evidence. For example, corroboration, witnesses with a possible interest to save, child witnesses, the rule against hearsay, exceptions to that rule, such as the res geste principle, dying declarations, etc. All these are very important because they are the ones that will stand in your way as you endeavor to put your story or evidence on the court's record. And as I said, and without the story being placed on the court record, there will be nothing with which you will persuade the judge to convict. You will also need to be well versed in or keep reading on the three classes of evidence, namely oral evidence, documentary evidence, and real evidence, and the particular rules governing each class of evidence and how it is introduced onto the record. Now, maybe I may go to how do you go about this before the trial? I think as counsel before the trial, you must study the docket thoroughly. It is at this stage that you must analyze the witnesses' statements and find the story that comes out of the totality of those statements. It is this story that will comprise the theory, as I have said. And when eventually you go to trial, your opening statement will be to the effect that your evidence intends to prove that story, which is what I have said. In order to get the story flowing properly, start arranging the witnesses in the order of the sequence of events. At this stage, you will start deciding which witnesses should be called first and which ones should be called last. It is important at this stage to start identifying also those witnesses whose testimony has some inherent weaknesses, and you strategize how you will redress or address the weaknesses. For example, for those whose testimony will require corroboration, you should identify the other independent evidence that will provide the corroboration, or look out for those circumstances which you will point out to the court as being circumstances which rule out the danger of false implication. This one, I think, I'm just giving by example because uh, I know that I think for most participants here, their jurisdiction, I think we follow the same law. But in case there are those who do not follow who do not apply the common law like we do in our jurisdiction, I think the rules may be slightly different. But what I'm saying here applies mostly to those who apply the common law jurisdiction. And this is the way we approach cases, issues concerning corroboration and so on. So you should pay particular attention to reports of experts, such as medical doctors, uh, which can be introduced on the record without calling the maker thereof. Again, this is I'm using an example from our system. Examine such reports thoroughly and satisfy yourself that they are clear and they state in a very clear manner what the report is intended to prove. So that if they are not clear, you should decide right from the beginning that you will be calling the medical doctor, for example, concerned to come and clarify his or her report. Another important thing is that you should look out for any contradictions or inconsistencies between your witnesses and find out what the contradiction really is so that you may address that. I can give an example. Recently, the judgment I wrote for the Supreme Court before I retired, we had a very puzzling case. This matter started in the High Court. It was a criminal case. It started in the High Court and came all the way to the Supreme Court. And the reason it came to the Supreme Court was simply that, you see, there was an apparent contradiction in the testimony between the medical doctor and the, should I call it, ordinary witnesses. I nearly said civilian witnesses. You see, the evidence before the trial court by the ordinary witnesses was that the injury to the deceased was at the back of the head. The evidence of the medical doctor who carried out the post-mortem was that he found an injury at the front of the head, not, of course, not on the surface, but inside. And that was the cause of death. Now,
I know there's protocols in place for this, and I know that
at the front. Of course, the trial judge was confused. Of course, not on the surface, but inside testimony, and that was the cause of death.
I know there's protocols in place for this, and I know
when
that
it's at the back, of course, the trial judge was confused. Of course, not made the finding to that effect. Inside testimony, and that was the cause of death. But then, as it turned out,
I know there's protocols in place for this, and I know
when
that
it's at the back, of course, the trial judge was confused. Put us made the finding to that effect. Deceased, who was her husband, fell in the bathtub and then hit himself on the taps at the back of the head. So when it came on appeal, yes. So when it went on appeal to the Court of Appeal, the issue arose as to which testimony the trial judge should have followed. Was it that of the medical doctor? And that was the cause of ordinary witnesses. But and then a lot of cases were cited around that on the taps at the back. That issue was it that the Court of Appeal doctor? And that was the cause of ordinary witnesses. But one one lot of cases were cited around that the other side taps at the back. That issue was it that the Court of Appeal doctor? And that was the cause of ordinary witnesses. The issue satisfactory. So the decision was cases were cited around they upheld the taps trial judge that issue, but by a majority of one. Was it that the Court of Appeal doctor? So that the issue satisfactory. So the decision was cases were cited it took the taps trial judge that issue, but by a majority of one. Was it that find out that it has to appeal the doctor? So the issue satisfactory. So the decision was cases were cited it took the taps trial judge. I guess that was decided by a majority of one. Was it that find out that it has to appeal the doctor? So you can imagine that was issue satisfactory. So the decision was cases were cited it took the taps trial judge. I guess that was decided by a majority of one. Was it that find out that it has to appeal the doctor? So you can imagine that was issue satisfactory. So the decision was however, it's not the decision and negative the accused defenses as they arise. So, as you read on the substantive law, you should identify and anticipate the possible defenses that the accused might want to adopt. You should then identify those witnesses or that evidence who or that rebuts those anticipated defenses so that you do not forget to introduce the evidence at the trial. Now, at the trial, having prepared thoroughly before trial, that rebuts those anticipated. However, I will say this. First, if the situation permits, try to call the witnesses according to the sequence of events. I can assure you, many times, I mean, the judge, the evidence has been presented anyhow, and really, it has been for the judge to look through that jumble of evidence to find out what the story is. It's quite frustrating, and sometimes, as a judge, you may miss out, or you may miss the very vital findings of facts. But whenever the evidence has been presented, in a sequential manner, starting from the beginning to the end, it tends to carry the judge along. To the almost to the point of being biased. You become so persuaded that you may even sometimes not see a mistake. But that is what then trial advocacy does. If the case is presented properly, it carries the judge along, and sometimes it can carry all the way to the to conviction. So I know from experience that here, at least in Zambia, if it's presented properly, in most cases it is difficult for the prosecuting counsel to put to those witnesses in conviction. So I know from experience that don't have the witnesses, at least in Zambia, when you presented properly. In most cases, it is difficult for the prosecuting counsel to put. But if you can, witnesses to conviction. So I know from experience that don't have the witnesses, at least in Zambia, when you presented properly. In most cases, it is difficult for the prosecuting counsel. Once you have managed to put your evidence on record, so I know from experience that don't have the witnesses, so when you presented properly. At this point, the issue of credibility becomes a prosecuting counsel. Once you have managed to put your evidence on record, so I know from experience that don't have the witnesses, so when you address any damage. At this point, the issue of credibility becomes a prosecuting counsel. Once you have managed to put your evidence on record, so I know from experience now don't have the witnesses, so when you address any damage. At this point, the issue of credibility becomes a prosecuting counsel. Once you have managed to put your evidence on record, so I know from experience now don't have the witnesses, so when you address any damage. At this point, the issue of credibility becomes a particular announcement. Also, you have managed to put your evidence on record, so I know from obviously having already a second case, when you address any damage. At this point, the issue of credibility becomes a particular announcement. Also, you have managed to put your evidence on record, the same applies to damage. Obviously, having already a second case, when you address any damage. At this point, the issue of closing arguments becomes a particular announcement. Also, you have managed to put your evidence on record, the same applies to damage. Obviously, having already a second case, when closing arguments any damage. At this point, the issue of closing arguments becomes a particular announcement. Also, continue arguments when the same applies to damage. Obviously, having already a second case, when closing arguments any damage. At this point, the issue of closing arguments becomes a particular announcement. Also, continue arguments when the same applies to damage. And point out having already a second case, when closing arguments any damage. At this point, the issue of closing arguments point out particular announcement. Also, continue arguments show the same applies to damage. And point out having already a second case, when closing arguments any damage. At this point, the issue of closing arguments point out then deal with it. Also, continue arguments show the same. So using decided cases, point out to the judge why, after balancing the two versions, yours should be the one that the judge should accept, and invite him or her to accordingly make findings of facts. At this point, you may now proceed with your closing arguments on the assumption that the judge has made findings of fact which are in tandem with your story or theory. You must then apply the substantive law to your version using authorities pointing out established fact which are in tandem with your story or theory, and every ingredient must then apply the substantive law. Having done so, you may now rest your using authorities seek the judge to convict the accused. Using authorities trial advocacy demands a lot of involved proof, theory, and every ingredient on the part of counsel the substantive law. Having done so, you requires a lot of using authority on the law of evidence pointing and the using authority trial advocacy demands a lot of preparation and a deep understanding on the part of counsel the substantive law. Having done so, you requires a lot of using authority on the law trial advocacy becomes using authority trial advocacy demands a lot of preparation and a deep understanding on the part of counsel the substantive law. Having done so, you requires a lot of using authority on the law trial advocacy becomes using authority trial advocacy demands a lot of preparation and a deep understanding on the part of counsel the substantive law. Having done so, you requires a lot of using authority on the law trial advocacy becomes using authority trial advocacy demands a lot of preparation and a deep understanding on the part
Good
of
morning once again.
having done so, you requires a lot of using
After that presentation by His Lordship, I was very much tempted to say thank you. The presentation is done. Good morning once again. I still think after that presentation, everything His Lordship has said, His Lordship can still summarize. I was very much tempted to say by His Lordship thank you by briefly highlighting the stakes in coming up with everything His Lordship said, case theory as well as the strategy. I was very much tempted to say by His Lordship thank you. What has been said so far? What is trial advocacy? Well, trial advocacy is the art of presenting a case or the skills and techniques used by lawyers to effectively prevent a case in court, aiming to persuade the court to rule in their favor. As His Lordship has stated, actually, I like the way he highlighting it's the art of carrying the court with you, aiming to persuade the court to rule in their favor. It is the ability to tell, His Lordship has stated, your story. Actually, I like the way he highlighting it's the art of carrying the court with you, aiming to persuade the court to rule in their favor. It is the ability to achieve that. His Lordship has stated, it is important that you have a story. Actually, I like the way he highlights your story. It's the art of carrying the it is this aiming to persuade the court help you structure your argument in their favor. It is the ability to achieve that in a manner that it is important that you have a story. I like the way he highlights your ultimately it is this aiming to persuade the court help you structure your argument. Ladies and gentlemen, how you to achieve that in a manner that it is important that you have a follow. I like the way he so ultimately what it is this aiming to persuade the help you structure what ladies and gentlemen how you achieve that in a manner that it is important as you can see follow you. I like the way he so ultimately what it is this aiming to persuade the help you structure what ladies and gentlemen how you in a manner I found one quote which says that you have to like the video that is what judges and review all evidence. What is your legal in I found one quote which says that you have to like the video that and what is most important. What is the question that is your answer that question. I found one quote what says that why judges and what is most important. What is the question that privilege of answer. I found one quote what says why judges and what is most important. What is the question that privilege of answer. I found one quote what says why what happened and what is most important. What is the question that privilege of because you want to determine what happened, we are also seeking what happened and what we need to because you want to determine what happened, we are also seeking what happened and what we need to because you want to develop theory is also subject what so we have to understand that what you want to develop theory is also subject how what features and support. So we have to understand that what you want to develop theory is also have what features and support. So what is there evidence to support is there evidence to support say that the fact or theory is there evidence in the component say that theory or theory once we do that is there evidence we have to in view of the potential reasons have to apply for you have to take as much as you are orchestrating what you are not saying, you are in view of the potential reasons having to apply for you are not taking as much as you are orchestrating what you are not saying, you are in view of the social reasons having to apply for you are not taking as much as you are orchestrating what you are not saying. I remember you are part we used to travel in view of the social reasons having to apply you are not taking but then as much as you are orchestrating what you are not saying. I remember you are part we used to travel in view of the social reasons having to apply you are not taking but then as much as you are orchestrating what you are not saying. I remember you are part we used to travel in view of the social reasons having to apply you are not taking but then as much as you are orchestrating I remember you are part we used to travel in view of the social reasons having to apply you are not taking but then as much as you are orchestrating I remember you are part we used to travel that is the story having to once you give that evidence but then as much as you are orchestrating I remember you are part we used to travel that is the story decided by magistrates and judges. It should anticipate decided by magistrates and judges reliable evidence. This is not to say that once you've set your case theory, you can't adjust. You can still adjust your case theory as you go, especially when it comes to the defense theory. At the time you are creating that theory at your office, you may not be fully aware of the defenses that they are likely to raise, especially that defense counsel in some cases come with what I can call a two-pronged or three-pronged defense, where they are not sure that, of course, their burden is easier. Your office. They are just trying to create may not that, be fully aware or something the defenses that they are likely to raise. Especially that defense counsel perhaps in some cases the defense theory come with something that has come up two-pronged or three-pronged you can still adjust your theory. Not sure circumstances. In the case I mentioned, when we're prosecuting, through cross-examination and through when we're trying to call witnesses, we noticed that some of our witnesses who were at the scene of the incident were resisting in coming to testify on behalf of the state. So at the back of our minds, we concluded that possibly that, of course, the incident they are likely to be resisting in coming to testify. So we did anticipate that, and we adjusted our minds. We concluded that possibly, so that eventually, when they were called in defense, challenge their evidence with the evidence that we had. They are likely to be resisting also in coming to testify. So we did anticipate that, and we adjusted our minds. We concluded to come and testify, so that eventually, when they were called in defense, good theory should be consistent that we have evidence also coming to testify. We did anticipate that, and we adjusted our minds. We concluded that testify, so that eventually, when they were called in defense, now is good evidence should be considered how we are going to bring this theory to life. Focus on this involves careful planning. So adjusting our system starts from how you introduce evidence eventually to how the next stage now if you look at the strategy going to bring this theory to life, focus on this involves careful planning. So come up with it starts from there introduce evidence eventually to how the next stage now evidence that you are going to highlight. If you look at the how you are going to bring this theory to life, witnesses and this involves careful planning. So come up with it starts from there introduce evidence eventually to how the next stage now evidence that you are going to highlight. If you look at the how you are going to bring this theory to life, by all means to present your voice as careful planning. Come up with it starts from there introduce evidence eventually to how the next stage now evidence that you are going to highlight. If you look at the how you are going to bring this theory to life, by all means to present your voice from careful planning. Come up with it starts from there introduce eventually to how the next stage now evidence that you are going to highlight. If you look at the how you are going to bring this theory to life, by all means to present your voice from careful planning. What I find very important there introduce eventually to how the next stage now evidence that you are going to highlight. If you look at the how you are going to bring this theory to life, by all means to present your voice from careful planning. What I find very important there introduce eventually to how the next stage now provide a summary of how you are going to bring this theory to life, by all means to present your voice from highlight what I find very for producing the submissions that you present. But as you are crafting this theory and the strategy,